is the 11th annual Over 50 Fair. This year's event is a charity conference, again, benefiting the Inn. We hope that you enjoyed our first two speakers. It is my pleasure to introduce Aaron Futterman as our next speaker. Aaron spoke at a previous Over 50 Fair and he was very well received. Aaron Futterman is an experienced and compassionate elder law and estate planning law partner at Futterman, Lanza, and Pasculi. Aaron Futterman's background as a certified public accountant makes it easier for him to resolve complex legal issues that arise in his estate planning, tax, and elder law practice. Their law firm started in Smithtown, and now they have offices in Smithtown, Bayshore, and in Garden City. For today's event, Aaron will be discussing elder law and the recent changes that could affect you. While change seems to be about the only constant lately, Aaron is going to make us aware of a change that most people don't know about, yet is very important. I will also put Mr. Futterman's contact information into the chat with all of his locations. Please welcome Aaron Futterman.
I've been busting at the seams because there's a lot to talk about. And this COVID-19 has really thrown me off, and I'm sure it's thrown a lot of people off in many different ways. I've seen actually a lot of horror shows, but I mean, one thing that's just turned upside down is I shaved on the weekend, and normally I'll let my beard grow on the weekend, but now with COVID, I've been letting it grow during the week because when I sit with people, I have a mask on and they can't tell that I have a beard growing, and then on the weekend now I got to go on the camera, so I shave for everyone. So what's the change that's coming up? And it's coming up very quickly, actually, unfortunately. The change that's coming to the Medicaid program, and it's affecting my practice and a lot of my clients and families, is beginning October 1 of this year. So in a couple of weeks, a pretty big change in the Medicaid laws is expected to begin, and that change is specifically regarding the community-based Medicaid program. And the community-based Medicaid program, and you know, I used to say, I think people are getting more and more familiar with it, but I used to say it was a hidden gem in New York State. There are two Medicaid programs in New York. One is the chronic program, which most people are familiar with, and that pays for someone who is eligible to be in a skilled nursing home. Medicaid, if the person is eligible, will pay that bill. The second program, the community program, is available for people who qualify, and the program pays for an agency to send home health aides to the house to assist with what they call, the term of art is the activities of daily living. What are the activities of daily living? The activities of daily living are the things I always say that we take for granted when we wake up in the morning. We get up and we transfer from the bedroom to the bathroom. We use the bathroom, we shower, we dress ourselves, we clean ourselves, we feed ourselves. These things that we kind of do half, asleep, sometimes people have difficulty with. Sometimes there's fears of someone's unsteady on their feet, someone could slip and hurt themselves in the bathroom or in the shower, and home health aides help. Medicaid will pay an agency to send home health aides to assist people that need this kind of help. Now, unlike Medicare, which, automatically when you turn 65, you get this like magic in the mail, you get this card and you all of a sudden are on the government health care program. With regards to Medicaid, this is, you have to affirmatively apply to avail yourselves of these benefits. And the program that I want to start talking about with, because it'll help distinguish the community program where the changes are coming up, is the chronic program. The chronic Medicaid in New York State, which pays for a nursing home, you have to apply, and in order to be eligible to have someone or to have the government pay for the nursing home, you have to pass 3 tests. Now, first, before I tell you the tests, why do people want Medicaid to pay for the nursing home? Well, here on Long Island, the average monthly cost of being in a nursing home varies between 15 to 17,000 a month. So, for most families, how long can you pay for this before you become destitute? So ideally, if someone were going to a nursing home, assuming it doesn't affect the type of care that the person gets, most families say, I'd rather see Medicaid pay. So how do you qualify? Well, the three tests. One, you have to have a need. And, you have to be in need of being in the nursing home, be a resident in the nursing home. Of course, I can't help you with this. And hopefully this never occurs. I always say to my clients, I hope you never go to the doctor again, let alone get close to entering a nursing home. But if you did have to enter the nursing home, hopefully Medicaid will be available if you pass the other two tests. So number one, you have to have a need. Number two, you have to be financially eligible. What does that mean? Well, most people, I think, know at this point that to be financially eligible for Medicaid means that you have to be poor. What's poor? You're poor in the eyes of Medicaid if you have assets in your name no greater than $15,750. This is the threshold line that I'm drawing. If you have assets that exceed $15,750, you're over-resourced. Medicaid would deny you. If you have less, well, assuming that you have a need and you have resources less than $15,750, assets, by the way, this is not income. If you pass test 3, you may be eligible to have Medicaid pay the nursing home. So the third test is one that many people have read or heard about, and there's a lot of misinformation about, and that's the 5-year look-back transfer penalty rule. And what this rule says is that when you apply for Medicaid, the applicant must submit records for the immediately preceding 5 years. So for the preceding 60 months, 5 years, you must submit all the bank statements, investment statements, tax returns, all the records must be disclosed for the immediately preceding 5 years. Why? Well, Medicaid is looking for something. Well, what are they looking for? Medicaid is looking for what they call uncompensated transfers. You and I would call these in everyday language gifts. Well, why are they looking for gifts? They're looking for gifts because they punish people that make gifts within that 5-year window. So let me pause here and say, any gifts made beyond 5 years are totally safe. And that's why folks come to sit in our office or sit with attorneys and try to plan ahead in a smart way. So what happens if Medicaid sees that the applicant has made a gift in the last 5 years? The answer is the applicant gets punished. Well, what's the punishment? The punishment is a period of time that the applicant is deemed ineligible. Of course, this period of time varies based on how much you gave away in the last 5 years. And the way that Medicaid calculates this penalty is they take the total gifts made over the last 5 years, so they would look at all the records and they'd add up all the gifts, and they would divide that by something called the regional rate. For Medicaid purposes, New York State is broken up into 7 regions, and Long Island, Nassau, and Suffolk counties are one of the 7 regions. And each year, each region is given a regional rate. And this regional rate is a fictional number that is supposed to represent the average monthly cost of being in the nursing home in that particular region of the state. And Long Island's regional rate this year is $13,407. This is the figure that they gave us. So if someone were applying for Medicaid in the nursing home, chronic Medicaid, and over the course of the last 5 years, they made gifts here, there, wherever, over the 5 years, these gifts totaled $100,000. Medicaid would divide that by the regional rate, $13,407, the quotient, 7.5 or something thereabouts. Medicaid would say, don't look to us. You had, or the applicant had $100,000. They could have paid the nursing home for themselves. They decided to give it away. So for 8 months, don't look to us. They round up effectively. And the family is forced to figure out how to pay the nursing home for 8 months. Month 9 and beyond, Medicaid would say, all right, you've served your sentence and we'll continue from this point on. But for 8 months, Medicaid doesn't pay. And I hope this helps to dispel a myth, which is that sometimes people say that, Medicaid is looking to take my stuff. Medicaid takes nothing. Medicaid simply denies an applicant when they are in the nursing home and they need help. They say, we're not going to help. Why? Because you made gifts lowering what you had available to pay the nursing home within the last 5 years. We're not going to pay. Now, I want to backtrack for a moment and tell you about test 2 for a moment quickly, because I do have limited time. Unfortunately, I have a half hour to crunch a lot of information in here. And test 2, you have to look poor. Sometimes people go, my goodness, $15,750. That's not much. I go, I know. And they say, do they count everything? And the answer is yes, Medicaid counts everything, but there are 6 exceptions. So the applicant can own 6 things that don't count when determining if they're above or below the $15,750 asset threshold. And the 6 things are: the applicant can own their personal effects. So, jewelry, household items, a fur coat, whatever it may be, doesn't count. Number 2, the applicant can own 1 automobile. The applicant could have bought themselves 6 months ago a brand new Cadillac, $50,000, fully loaded, doesn't count. 1 car. Number 3 of 6 things that don't count. The applicant can own a burial plot. And I always say, isn't that nice? They let you keep your burial plot. The 4th thing that doesn't count is kind of related to the 3rd, and that is a prepaid funeral trust. And this is money that you set aside at the family funeral parlor, and you prearrange what's going to happen when the time comes. You prepay for casket, services, prayer cards, etc. Whatever you set aside, you could set aside $20,000 for this beautiful funeral. Doesn't count towards that $15,750 threshold of assets that you're permitted. So those first 4 things are easy. If you own them, they just simply don't count. The last 2 are a little tricky. The 5th thing that does not count against an applicant is qualified retirement accounts if you put them into a regular monthly payout status. So first, what are qualified retirement accounts? These are people's IRAs, 401ks, the tax deferred accounts when you were working and you were putting money aside and it was growing tax deferred. And then when you turned 59 and a half, you could start to withdraw without a penalty. And it used to be under the old law, you had to start taking that minimum distribution at 70 and a half. By the way, now it's age 72. You have to start taking that minimum distribution. Those accounts can be made not to count against the applicant. So, that's pretty significant sometimes. These accounts can grow to, 6, 7 figures sometimes. So the example I often give is, family comes to me, they tell me that mom is entering the nursing home. And I say, well, if we're looking for Medicaid, what does mom own? And they tell me that, well, the only thing mom owns is this IRA. And I say, well, what's the value? And they tell me $100,000. If we were to apply for Medicaid, having done nothing, she's over-resourced. However, if we put that IRA into a regular monthly income stream and mom withdraws a particular amount based not on IRS figures, but on a Medicaid distribution chart, Medicaid will ignore that $100,000 IRA from counting as an asset when determining if they're poor or not. The question then becomes, well, what happens to that monthly income? And if mom is a widow, and for anyone who is either single or a widow on chronic Medicaid in the nursing home, that person's income is expected to go to the nursing home every month, and Medicaid will pick up the difference each month. So that would be just one added source of income to probably Social Security or a pension, that monthly amount from the IRA or qualified retirement account. But understand, if they wanted to preserve this account to the named beneficiaries, number one, yes, it gets a little bit less each month because you're taking some out. But if there is a balance in that account when the Medicaid applicant meets their maker, that will go to the named beneficiaries without any Medicaid claim or lien. So it's a way to protect certain valuable assets. Qualified retirement accounts, the fifth thing that doesn't count. The last thing that doesn't count against an applicant when determining if they're poor or not, I'll preface this by saying this is a trap, is the applicant's primary residence. So this is a trap. I got to tell you this. So the example I give is the family again comes to me. They say, mom's going in the nursing home. I say, what does mom own? They tell me mom owns the house. They tell me, the kids tell me that mom has spent everything. Mom has nothing left. The kids have been helping mom pay the taxes, the upkeep, the maintenance, the insurance. The only thing mom owns is the house. And I say, well, is it her primary residence? Yes, it's been her primary residence for 50 years. I say, well, how much is it worth? And they say, well, funny you should ask. We were going to talk to mom about selling it. We had it appraised. It came in at $750,000. I go, okay, well, we can apply for Medicaid and Medicaid will pay the nursing home. And the kids look at me with these question marks flying out of their head. And they say, wait a minute, we just told you our mom owns a house worth $750,000. She's eligible for Medicaid. I go, yeah, the primary residence doesn't count. As a matter of fact, she can own a house worth over $850,000 in equity, and it doesn't count against her. We can apply, Medicaid will pay. Here's the trap. The trap is Medicaid will put a lien on that house, and they'll pay each month, and this lien will get bigger and bigger and bigger until mom passes away. Medicaid will then sue the family to force the sale of the house to recover what they paid on mom's behalf. So it's a trap to believe that the house is safe. It's safe while mom's alive. When mom's gone, now they want their money, and they will have put a lien on the house to ensure that there's a source available to pay. So chronic Medicaid. Number one, you have to have a need. Number two, you have to look poor. Number three, 5-year look back transfer penalty rule. So what's the big change that's come down the turnpike? The big change has to do with community Medicaid. And I had said in the beginning, community Medicaid pays for would pay if someone's eligible, a aide to come to the house. As a matter of fact, it also pays not just an agency that might send some strangers, but there's also what they call the consumer-directed program. Now, I see many TV commercials, infomercials regarding this. These services are to help people get these family members paid. This is what this is, community Medicaid. And to qualify to have these home health aides help people stay safe and in their home, you have to, again, pass several tests. Number one, you have to have a need. That need is determined by a nurse that comes to visit mom in the house, and they do an assessment. And this assessment will determine what limitations and capabilities are, and it'll result in a number of hours, number of days a week that Medicaid would pay for an aide to help mom in the house. Number one, you have to have a need. Number two, again, you have to be financially eligible. It happens to be the same definition. You must look poor. Assets less than $15,750 in your name. Test 3. This is the change. The look back period. Believe it or not, right now on September 12th, 2020 in New York State, the look back period, 0. Nothing. What does that mean? That means theoretically, you can give away everything you own today. Make yourself look poor. October 1, you're eligible for community Medicaid. There's no look-back transfer penalty. Zero. What's changing October 1, and it's been, by the way, it's been that way for many years. What's changing October 1 is starting October 1, there will now be a 2.5-year or 30-month look-back transfer penalty, meaning gifts made after October 1, 2020, if you apply, and there are gifts, they'll see these, and will punish the applicant with the same calculation we spoke of for chronic, meaning they'll take the total gifts made in the 30-month look-back, divide it by that regional rate, which on Long Island is $13,407. The quotient will be the number of months that Medicaid says, listen, we're sorry you need help in the house. Don't look to us for this amount of time. Now, I'll also say that starting October 1, this look-back penalty rule comes into effect. But in a similar fashion, when the chronic Medicaid, sometimes people will say, I remember when it used to be a 3-year look back for chronic care, and then they changed it to 5 years. Well, when that change happened, it wasn't that on a certain date, all of a sudden magically went from 3 years to 5 years. It actually took 2 years for it to become a 5-year look back, meaning when the law changed, 1 month after the change in the law, it became a 3-year, 1-month look back. 2 months after the law was enacted, it became a 3-year, 2-month look back. Same here. So October 1, when the law is enacted and it's effective, there'll be a 1-month look back. In November, there'll be a 2-month look back. Until 30 months later, it will be a full 2.5-year look back transfer penalty. So we have been absolutely buried with families calling us, trying to make transfers prior to October 1. Well, I'm getting the 3-minute warning here. So I'll see if there's any questions, and if there are questions, I'll try to answer. Okay, no question. Okay, I'm looking. All right. Well, if there are questions, we do offer a free consultation. You're more than welcome to give me a call. I'm happy to answer. I will say, though, lately, at least I imagine until October 1, I have a feeling we've been absolutely buried with families trying to get in, apply, or transfer assets to family or to trusts to do smart planning before this effective October 1 date. Now, I will tell you this, in truth be told, we've been getting, and when I say we, the Bar Association has been getting indications from New York State that they're really not going to apply this law until January 1. But I don't like to take chances. The statute says October 1, 2020 begins the look-back transfer penalty. So if anyone out there has been on the fence as far as whether to do planning, whether to sit with an attorney, try to get in there. Try to do it now. A quick question here. Are stock investments counted against you for asset versus qualified IRA? Well, if the stock investments are non-qualified regular accounts, yeah, those are assets that count against you. If they are in a qualified retirement account, then those could be made not to count against the applicant if they're put in that regular monthly payout status. That's a confusing concept that comes up a lot. I'd be happy to discuss that further if you wanted to give me a call. So I think I'm getting the high sign here. I don't know what I need to do to sign off or to segue, but I appreciate everyone's attention and thank you. Have a good weekend, everyone.